Sorry, thank y'all for coming. How's everybody doing? Y'all don't have to respond. Thank y'all really for coming. This is the first full house we've had since we started these back up this year. So thank y'all. And I know some of y'all aren't getting the emails. We're working on the technology. If you have a Roadrunner email, you're not getting the email invitation. So we apologize. We're working on that. Couple things. Does everybody have a handout? Everything that you're going to see on the slide is in your handout. So you really don't need to read the handouts. Want to make sure everybody knew, if you have friends or family that want to be added to our guest list here, this is our investment supper reminder card if you want to take one of those. And also, we usually put these in. We had our tax seminar a couple months ago, and if you didn't get one of these, this is the 2022 tax data, these nice little cheat sheet. If you want one of those, we have those. It's not in your handout. There is in your handout a comment card. Hopefully everyone gets one of those. You're still doing that, right? Yeah, I'm just kidding. The comment card is your, obviously we want to hear your comments. We need to know what topics you want to hear about next year, or thoughts on this one, thoughts on new ones. But it's also, and how the speaker did, if we need a new speaker, that kind of thing. But it's also an entry into the gift for tonight, the door prize, which normally is a gift certificate to somewhere. But tonight it's a very, very important one. And it's a gift certificate basically to Chris Schoessow. It's the powers of attorney. If you don't have a power of attorney, medical power of attorney, directives to physicians, and HIPAA directions, they're going to do that for you or your family for free with this gift. And it's so important. That's why we want to explain it ahead of time before the presentation, because if you don't have any of those documents, it's very important to do so. So that's the gift tonight, very special gift, thanks to Chris Schoessow, who our speaker that I'm introducing. He's from Fredericksburg, born and raised, graduated from FHS salutatorian. Went on to Baylor University, where not only did he play fullback for the Baylor Bears, he got his BBA in marketing, management, and entrepreneurship. And then he stayed in Waco and got his law degree at the University School of Law. And lucky for him is that's where he met his lovely wife, Gail, who is also an attorney with him at Bryla and Schoessow. Bryla and Schoessow. Sorry, I said that wrong. So she usually does these presentations with him, and they've done this together in the past, and we love their banter and their dual presentation. But since then, they've had their fifth child, so they're a little busy. So she couldn't be here tonight. She's got practice times 3 or something like that. So Chris could be here sharing his time to share his knowledge with us. He's board certified estate planning and probate law attorney, certified by the State Board of Legal Specializations, meaning he's really good, and that's really mostly what he does. He also cares about his community like we do. He volunteers. He's the chairman of the board of the Hill Country Hospital Foundation. I'm on the investment committee. He's the chair. I love working with him on the foundation. He's also on the board at Honor Veterans Now, which helps feed hungry veterans. He's also executive committee on the Wild Game Dinner, which helps raise money for youth agriculture education. And he just completed his committee membership on the 175th anniversary of Fredericksburg. So he really cares about the community. He cares about educating people like we do. So please help me welcome Chris Schoessow.
Thank you all very much for coming. I know this is one of the most popular talks that Jody and them put on, and we're happy to give it. We like to let y'all be informed. A lot of people don't know what they don't know, and we always leave time for questions at the end. If you've got questions during the middle, let me know. If I'm going too fast, if you can't, yes, louder?
Louder.
Okay.
Please.
I'll try.
We're old.
Well, I yell at my kids a lot, so I might lose my voice.
Use your daddy voice.
That's right. Okay, so what we're talking about today is basically the essentials of estate planning. We're not going to get into a lot of specifics because I want y'all to like me when this is over, and I don't want your eyes to glaze over or you to fall asleep. That being said, we're not going to get into specific tax discussions or anything like that. This is just meant to be a broad overview about wills, powers of attorneys, other estate planning tools that you have out there available. So we're going to talk about just the basics of estate planning, wills and probate, trusts, powers of attorneys, and then how you get started and what you do to keep everything current. So a little bit of the estate planning basics, and I've got this on an old slide, so I'm sorry I don't have it up here. But, why do you get your estate plan in order? Well, one, so you can manage your assets and you can manage your affairs, both while you're alive, and you can get them set up for after you pass away. One thing everybody needs to figure out is who's going to handle their affairs, both when you're alive, if you can't do so yourself, or after you pass away. There's a lot of special situations that are more than just simple will situations. We have a lot of blended families. We've got charitable intentions, and we've got special needs family members, so those require special attention. One of the things that I advise people to do is surround yourself with good people that are smarter than you in different areas, because I'll be the first to tell you that I don't know everything. I go to Jody and them all the time with questions. I go to my CPA with questions. If you surround yourself with people that are smarter than you in those aspects, then you're ahead, that's for sure. So what are the reasons for having an estate plan? One is that you avoid the state of Texas from deciding who gets your assets and who is handling your affairs if you can't. There's a lot of unintended consequences that if you don't have a will or estate plan in place, your intentions may not be followed and your goals may not be reached. Also, tax considerations. You don't want to have your beneficiaries be taxed when you pass away, or you want to minimize your taxes during your lifetime. So we'll talk about some planning tools now. What are available to you to get your estate plan in place? And we'll talk about these in more detail, so I'm just going to mention them right now. We've got our wills, which is the customary tool that people use. You might be surprised to find out that only about 40% of people have wills in place. Some people just don't want to talk about it. They think if they get a will signed, they're going to die the next day. Other people say, well, I'm too young to have a will. Well, you're never too young, especially if you have kids. You need to set up who their guardians are going to be if something happens to you. And I tell you what, if you can get in a vehicle and drive down Highway 290, you are not too young to have a will. Trusts are another estate planning tool. They're a little bit different than wills. They pass outside of probate if you pass away. We'll get into those a little bit too. There's about 1,000 different types of those, so we're not going to touch near all of them. You can plan with making gifts, either charitable gifts during your lifetime, gifts to your family members, to your children, and then gifts when you pass away through your will or through your trust. Life insurance. We used to have a lot of life insurance involved with estate plans because, believe it or not, back in 2000, our estate tax exemption was $675,000 per person. That's not very much in today's dollars. If you've got a house and a retirement plan in Fredericksburg, you're over that. Now, life insurance is more of an investment tool because you can get a pretty good return on, or your heirs can get a pretty good return on your money if you've got some laying around. But we don't use it as much for estate taxes as we used to because we've got such a high estate tax exemption, which is $12 million per person, or $24 million per married couple. You can do rights of survivorship on different accounts, beneficiary designations on accounts. You can do life estate deeds. All of these are planning tools that you can use in your estate to get everything set up the way you want. One thing that a lot of people don't do is they don't realize to get their business planning in order. There's a lot of people that have sole proprietorships that run businesses to where they don't have an entity set up like an LLC or a partnership or a corporation. And I had a client who had a restaurant and he passed away and it was a sole proprietorship. He didn't have anybody there to write the checks, to be the manager. The owner was gone. They had to wait for the probate process, close down the business for about 2 months before they could open it back up. So you want to get together with your CPA and your advisors on whether or not to set up a business plan, to have an entity in place if you've got a family business. The next thing we'll talk about is taxes. Like I said, this will be short and sweet. It won't be too complicated and in-depth. Each year they kind of adjust our estate tax exemption and our annual gifting exemption. This year they knocked it up from $15,000 to $16,000 per person per year. So you can walk down the street handing everybody $16,000 bills, and we don't have to tell the IRS that you gave that much money, and they don't have to tell the IRS that they received that money as a gift. When you do that, let me know. I'll meet you on the corner, and then I'll have some food for the kids. So a lot of people take advantage of the annual gifting. Some people do it for college purposes. You can fund a 529 plan for a kid. Some people pay that for tuition for their kids or grandkids. Some people just do annual gifts because they've got cash laying around and they want to start moving some of that out of their estates. And what you can do is, if you're a married couple, you can double up and you can give $16,000 each, $32,000 per person. If you have a child that's married, you can give them and their spouse $16,000 apiece and double up with that as well. What's our estate tax exemption or our lifetime gift exemption? We've got $12.06 million right now that we can pass away with and or give away without paying any tax. That's significantly higher than it used to be. We were a little worried the last couple of years that would be reduced. They certainly talked about it. They just couldn't come up with an agreement to get it done. This is set to sunset in 2025 and go back to $5 million per person unless somebody changes it, which somebody probably will. They call it permanent, but it's only permanent till the next administration can agree on a change. I do think that that's going to be reduced, unfortunately, back to around $5 million per person, because we have such a big deficit and our spending is so much that we need to get funds somewhere for our government, and the easiest place is by a death tax. I don't like it. I don't see it coming next year or the year after that, but I can see it in 5 to 10 years down the road. So even though we call this the estate tax exemption, our government lets us use that during our lifetime. Think of it as a big pie, and they let you take slices of that pie during your lifetime. So if I want to give $1 million to my child, which is what I feel like I give them, then I have to file an estate tax return or a gift tax return because it's more than the $16,000. But all it does is it reduces my $12.06 million by the excess of what I gave. So I still don't have to pay tax until I get over that $12 million number. What are some exceptions to taxes? Well, a spouse can give their spouse an unlimited amount of money. We don't have to report that. We don't have to tell anybody. We can just give unlimited gifts back and forth. You can give, obviously, make charitable donations. Those don't count against your $12 million gift or lifetime exemption. And then you can also make gifts directly to a child or grandchild's school for tuition or to a hospital for medical expenses, and those don't count against your lifetime exemption. I touched on this just a little bit, but historically our estate tax exemption, like I said, in 2000 it was $675,000 per person. 2010 it jumped up to $5 million per person. And then in 2018, it jumped up to $10 million per person, and that's where we are now. It's just adjusted for inflation each year and goes up a little bit. And these are our federal taxes for our IRS. Some people wonder, well, does Texas have, income taxes? Well, no, that's why a lot of people are moving here. We don't have individual income taxes, and we don't have inheritance taxes. We do have what's called the franchise tax, which is taxable to some businesses if they make a certain amount of revenue per year. A lot of them don't. So we just have to file a franchise tax return on an annual basis for businesses, and most of them say we didn't meet the threshold of income. One thing that's extremely important is with your bank accounts, your investment accounts, with your retirement plans, with your IRAs, there's a beneficiary designation available for you to use. A lot of times that helps save a lot of trouble. It doesn't tie up money. It allows somebody to have access to those funds when someone passes away. If you don't, sometimes you've got to wait for the probate process, and your child may not have access to cash for funeral expenses or something like that. So naming beneficiaries is very important. Get with Jody and them on that, because we want to make sure, and we do talk a lot about how the account's supposed to be set up in conjunction with their estate plan. So if we've got mutual clients, we go back and forth and say, how should they do it? Well, they want to do it this way. Okay, Jody emails me, says, do you want it like this? And I say, that's perfect. So we do work together a lot, and that's very important to do. If you don't have beneficiaries, oh, I guess I can use this thing. On the IRAs, 401ks, or pension plans, that can have extremely adverse tax consequences. If you pass away, usually your beneficiaries can choose to roll out the IRAs or the retirement plans. If you don't have a valid beneficiary designation listed and it goes back to your estate, then that's treated as 100% distribution and all taxable. So it's better to give your beneficiaries the option of whether to roll it out, or if they just want to take it all in a lump sum, they can do that, but at least that's their decision. Same thing with life insurance. A lot of times we'll just put a beneficiary designation on life insurance for whatever reason, but we'd certainly want that as opposed to coming back through our estate, because if you go back through your estate with any of these, then if you have any liabilities, they can attach to those different plans and insurance. If you've got a federal retirement plan that's governed by ERISA, it's very important to know the rules with that. Basically, what the federal government says is you've got one of these plans, your spouse is automatically the beneficiary, unless they sign off on it. So we've got a story about our character named Jane. Jane's got a 401k plan that's governed by ERISA. She wants her kids to be beneficiaries of that plan. Her husband agrees, he signs off on it, all is well. Husband passes away, Jane is still alive. Jane gets remarried, doesn't think about her new husband having any sort of ownership interest or beneficiary designation for that, because she has her kids listed still. Well, Jane dies, and because it's a federal retirement plan, her husband gets all of the money and not her kids. And that happens, believe it or not. We've had probably 3 or 4 of those in the last 5 years where we've had to go and do a family settlement agreement because everybody knew what the intention was, but that surviving spouse just didn't want to give it up, even though they didn't think it was theirs. So, the lesson to learn about that is if you do have a 401k or an ERISA governed plan and you want someone other than your spouse to receive the benefits of that, make sure that they sign off on it and work with your advisor. What are some potential problems with naming beneficiaries, and what goes into our thinking when we're designating beneficiaries on our retirement plans, our financial accounts, our life insurance? Well, one, are they too young or too old? Do I want my 2-year-old daughter inheriting my IRA? No, because she's 2. And I'd have to go get a guardian set up with the court to oversee her assets until she's 18. Are they too old? Are they on some sort of assistance plans? Are they on Medicaid? Is it going to invalidate them if they receive those benefits from continuing to receive Medicaid? Are they going to have to pay back any benefits they've already received? Are you charitably inclined? You can name, a lot of people name charities on their IRAs as beneficiaries, and that's a good tax write-off for income tax purposes. You can name trusts as beneficiaries. Some people set up trusts for their children during their lifetime by making gifts. And one thing that they can do is they can name their children's trust as a beneficiary of a life insurance policy. One of these, and this is so outdated with our language, it's archaic, but that's the way the law works a lot, is you may see something called per capita or per stirpes if we do a will for you guys, or if y'all are reviewing your will. Basically, what it means is per capita means everybody gets an equal share. It doesn't matter if they're your son, your granddaughter. You know, if I've got 2 children and one of them pass away, and that one that passed away has 5 kids, and I say everything goes per capita, then everything goes in 6 equal shares. So my deceased son's 5 children get 5/6 of the assets when my surviving son only got 1/6. So that's per capita, and that means per person. And then per stirpes is what most people do. Per stirpes means per family unit. So if I have the same scenario and one of my children predeceases me leaving kids, well, his kids will get 1/2 of the assets and my surviving child will get the other half. And that's usually what the intent is, unless there's extenuating circumstances. One thing that's also important is to name a secondary beneficiary if you have the option on your accounts. Why is this? Because, well, when you get up in age, your primary beneficiary may pass away, and you may be too old at that time to actually change or put a new beneficiary on there. So it's always good to have a primary beneficiary and secondary beneficiaries, and most times it's our spouse and then our children. Also, you may want to have a charity listed as a beneficiary of a retirement plan or a life insurance policy. Well, if that charity is not in existence when you pass away, then you might want to have a backup beneficiary or another charitable organization listed. And if I'm going too fast or y'all have questions, let me know, please. Okay, so we'll get a little bit into more detail about wills, about powers of attorneys, and about trusts in the next coming slides. So what does a will do? Well, one, it helps you avoid state involvement, the state of Texas, with your estate and what your affairs are. So you can, first of all, name an executor, and the executor is the person that handles your estate. Secondly, you can spell out the distribution of your assets. You can do it by specific bequests where you say, this child gets this car, this child gets this gun, and you can make it as specific as you like. Or you can make it as general as you like and say, all of my personal property goes equally to my children. I had a client that had a list of about 20 pages that included about 1,000 Hummels to go to different people in their will. And luckily she had time that she could put a name on the bottom of each one of those, because otherwise that would have taken up a ton of time. So you can spell out the distribution of your assets specifically and generally. And if you do not have a will and you pass away, and some of you may have had experience with this, is it's called intestate succession with the state of Texas. Basically, there's a family tree set up in our estates code that says where your assets go if you pass away without a will. And there's a lot of factors with, are you married? Do you have children? Do you have separate property involved in your estate? So that's, the main thing we try to avoid is the state being involved with your estate plan and with your assets. And so wills can be as complex and as involved for tax consequences, or they can just be simple. And I will tell you, I do get a lot of funny looks when someone comes in for a simple will. Our simple will is 7 or 8 pages. It's not 2 pages like the ones that were drafted in 1971. Because we have to put tax language in there. We put executor powers. They've evolved a little bit. So even our simple will is 7 or 8 pages. Complex, wills with trusts in them, get up to 30 pages. So there's all different types of wills for each specific situation. Everybody hears bad things about probate. It's going to cost a fortune. It's going to take years. We want to try to avoid it at all costs. Well, that would be true. Well, I will tell you, Texas is pretty simple when it comes to that. We've got a streamlined process where we go to court one time. The judge says the will is approved. You're appointed the executor. Now go do what the will says. We don't have to come back to the judge every time we want to do something. A lot of times I'll let my clients do a lot of the stuff on their own. Sometimes I have to hold their hands, though, through the whole thing. A lot of the horror stories come from other states. California is a bad probate state because they've got what's called dependent administrations, which means that everything the executor does for the estate, you've got to go get court approval with your attorney to do that. We had a gentleman that had a condo in California. He was a Texas resident. Just to sell the condo, it cost 30% of the sales proceeds for the estate costs for the attorney. Florida's not a good one either. That's why people that move in from out of state a lot of times, they have living trusts. And that's so that their assets go through their trust and they don't have to go through probate. Timing issues, like I said, it's pretty simple in Texas. We can usually get a will probated within a month of someone passing away. We'll get calls after people die and people say, when do we need to bring in the will? Well, take your time. You've got more important things to take care of unless you've got an emergency. There might be somebody that's locked out of their bank accounts because they didn't have the right beneficiary designations. Well, yes, then we need to bring it and we need to probate it more quickly. But I'd rather have people take care of their family and be with them during that time and then bring me it later so long as there's not an emergency. So who's the important person in our will? Well, that's our executor. That's who handles our estate. That's who you choose to follow through with your goals. So if you say your daughter's the executor, but your beneficiary is your son, well, you better trust your daughter to make sure everything gets followed through with and your son gets those assets. A lot of times, not a lot, but sometimes we have situations in which the executor doesn't know that they've been appointed as the executor. So that's always a good thing to talk to them first and, at least let them know so it's not a surprise. You can always decline to serve as an executor. You don't have to serve. So even if you talk to them and they say, I don't want to do it, you can still put them in and then maybe guilt them into doing it when you're dead. So that person is somebody you should trust a lot, and you don't want a minor child to be your executor. You don't want to put your dad as the executor when he's 99 years old. So some thought does go into that. There are ways, and I will tell you they don't happen very often, that you can avoid probate. Some people say, and you may have gone to a dinner where somebody came down from Dallas or Houston and had a trust seminar and said, probate's bad, probate's bad, probate's bad. Here's a pretty $5,000 trust in a pretty red binder. That's what you need. You don't need that. But there are situations where you can avoid probate. Most of these are in situations where there's not a lot of moving parts to your estate. I had a client recently that had a house and had a bank account, and we did a life estate deed for the house. So she said, it goes to my kids, but I reserve the use of it for my lifetime, and she put them on as beneficiaries on her bank account. She passed away, everything went to her kids, there was no need for probate. You can avoid probate by gifting assets away during your lifetime. You can do transfer on death, clause of TOD, you may hear from a bank or a financial institution, pay on death accounts, and then retirement plan and investment account beneficiaries that you can put in place. So there's ways that not necessarily to avoid probate in everything, but there's ways to get a good chunk out of probate by putting these different beneficiary designations or life estate transfers. We talked about the executors a little bit. They've basically got 3 jobs. Okay, the first one is they identify and gather your assets and make sure that they're safe, right? So we go through your file cabinets, your boxes of paper, and we see, what accounts you have, what life insurance policies from 1967 you have, and we just have to collect all the assets first and foremost. Secondly is they pay the debts. If you've got debts of your estate, if you've got, past income tax returns that haven't been paid fully, we take care of those debts through the estate. There are certain assets that are exempt from the estate debts. Your homestead's usually exempt, and then you've got a certain amount of personal property that's exempt as well. Your executor does prepare an inventory once they find all of your assets. We typically have 90 days to do that after we probate your will. You can ask for an extension. Some people don't like the idea of probate because they hear, well, it's public record. You can see everything that I own if you go up to the courthouse and you're nosy enough to look at it. Well, in 2013, they changed that and said, you don't have to file an inventory with the court anymore. You can file what's called an affidavit in lieu of inventory. That doesn't mean that you don't have to prepare one, but you just don't have to file that and make it public record. You've got to prepare it. You've got to give a true and complete copy to the beneficiaries. We just don't have to make that public record anymore. And that's not something a lot of people know, because that's why they like trusts, so that they can go around probate without having to share this information. And then once you've gathered the assets, once you've prepared the inventory, once you've given notice to the beneficiaries, once you've paid the debts, then whatever's left, if anything, goes to your beneficiaries in your will, and that's your executor's job to do as well. With most of our normal estates, we're usually anywhere between 3 and 5 months to get everything handled completely. There are some exceptions. There's bigger estates that require a federal estate tax return, which can drag on for a year or so. There's beneficiaries that fight and argue. Those can drag on as well. So when I say probate in Texas is easy, it's generally easy and generally without problems, but there's always exceptions. Next, we'll talk a little bit about trusts. Again, there's about 1,000 different types, so we're not going to get into all of them. So trusts can help you manage your assets. I'm not against trusts. I just want to make sure that the situation is right for them. I don't push trusts and say probate's bad, wills are bad. For instance, if I've got a client with out-of-state property, I might suggest having a trust form to hold that out-of-state property so that we don't have to probate your will in Texas and in New Mexico, or in Texas and in Colorado. If it's in a trust, it just passes to the beneficiaries in that trust and you don't have to probate it. It can help you manage assets as well. Let's say I've got a 90-year-old client that doesn't have any children around, that can't help with their bank account. They may say, okay, well, we're going to set up a trust and I'm going to let LPL be the trustee, and they're going to take care of scheduling my bills paid. They're going to take care of my assets and my electricity. So there's a way that we can help manage assets for certain people. Trust can also protect assets. One thing we do quite a bit of, well, not as much anymore, but we did a lot of in 2012, was we created trusts for a bunch of our clients' children. Because the estate tax exemption was looking like it was going to go back down to $1 million per person, and people started saying, oh my goodness, my kids are going to go owe estate taxes, so they started making gifts to these trusts. Well, the good thing about those trusts for the kids is you can make them to where they're not attachable to that child's liabilities. If they get in a car accident in college, they can't get into these trusts. If they get divorced, their ex-spouse can't claim. You've got to divide that trust up between the two of them. And then what they also do is whatever goes into what we call these generation skipping trusts for the kids, is it avoids being liable for estate taxes for a few generations down the road. So, it sounds really good, and it is a good tool. People ask me, what's the bad part about them? Well, you have to file a tax return. That's it. So I think the benefits greatly outweigh that on these trusts. We've talked about how trust assets can avoid probate. I've had 2 clients in almost 20 years that have avoided probate just by using a trust, and they were good at it. I mean, everything they had was titled in the name of the trust. Their vehicles were titled in the name of the trust, and they successfully did it. What we do when we prepare trusts is we also prepare a will just in case, because we're sure that something's going to get left out and you're going to have to probate the will anyways. So we do both of them when we do trust planning. Tax planning, we discussed that a little bit. You can do tax planning by making gifts to trust, and we can avoid estate tax problems potentially. What type of trust categories are there? Well, there's two main ones. There's a lot of subcategories like charitable trusts and stuff like that. But for the main part, you've probably heard of a revocable or a living trust. And that's a trust that you create during your lifetime. You can amend it. You can add things to it. You can pull things out. You don't have to file a separate return for your taxes. Everything gets reported on your own return. Now, one thing about the living trust is there's no liability protection. Some people think if it's in a trust, then if I get sued, they can't get to it. Well, with a revocable living trust, because you can take things out and put things in, they say that your trust assets are liable if you have a judgment against you. Irrevocable trust is the second major group. These can be created during your lifetime, like we talked about for our children. They can also be created in our wills, if we do tax planning in our wills where we want to keep our assets during our lifetime, and then the kids get whatever's left, if anything. Irrevocable trusts cannot be changed. There's a couple of exceptions. We can put language in there that says a trustee can select their successor trustee. We can't really change the dispositive provisions or who the beneficiaries are, but we can change trustee provisions. With the irrevocable trust, we talked a second ago about what's the bad part. You got to file a tax return. If you have an irrevocable trust that earns income, then that income gets taxed at a much higher rate, much quicker than your individual tax rate. If you leave the income in the trust, you're going to pay the max tax bracket at about $10,000. If you distribute it out of the trust, the income to a beneficiary, they pay it at their personal rate, whatever that is. We talked about the living trust or the revocable trust a little bit. You've got full control of your assets. You can put things in, you can take things out. You can always change who the beneficiaries are, who the trustees are. You can avoid probate with those assets that are in there. I've got a couple of clients that may have a ranch or may have a big investment account, and they don't care about avoiding probate totally. They just want their kids or their spouse to have access to the ranch or to that retirement account or to that investment account without having to go through probate, because it's typically a little bit quicker. And again, there are no creditor protection or tax advantages to a living trust. It's just like you own those assets individually. These are a couple more examples of trusts. You can set up a charitable trust. You can set up life insurance trusts, which we used to a lot more when the estate tax exemption wasn't so favorable. A lot of times grandchildren or grandparents set up trusts for minors, We used to do a personal residence trust quite a bit. We really don't do those anymore. Charitable trusts, you can set them up where the charity is the beneficiary right away, or you can reserve an income stream for the rest of your life and then have it go to charities after you pass away. These are just some of the types of trusts. There's a lot more that are out there. Next, we'll talk about who our decision makers are. And this is probably, one of the top two most important things we're talking about tonight. So what would happen to you if you couldn't handle your affairs? Who would make those decisions for you? What decisions are we talking about? We're talking about your medical decisions. If you can't make your own decisions known to a physician, they're going to look to somebody else to make those decisions. The state has a list of, if you don't have a medical power of attorney in place, who makes those for you? Is that the person that you want? So you may have a child that's a banker, and you may have a child that's a nurse. Well, that may be the person that you want to make your medical decisions for you. Who's going to make your financial decisions? If you can't pay your bills, who's going to do that for you? Do they have access to your bank accounts? Do they have to pay with their own money because you didn't leave them with the power of attorney or the ability to access your own accounts? The first thing we'll talk about is a financial power of attorney. It's also called a statutory durable power of attorney. What it does is it gives somebody that you've listed in that document the ability to handle a broad range of matters on your behalf, whether it's just banking, whether it's real estate transactions, commodities, stocks, bonds, oil and gas, Can they set up a trust for you? Can they deal with the IRS on your behalf? You know, there's a ton of things that you can give somebody the ability to do. Most people appoint their spouses and then put, you know, their children as backups or their close friends as backups. The good thing about it is, you know, we've got the ability to make it effective immediately when you sign it. Or you can say, you know what, I want my son to be my power of attorney and be able to handle my financial affairs if I can't, but I don't want him to run my bank account down while I'm alive. Well, so you can make it effective only upon your incapacity. So we can spring it in motion when you can't absolutely do your own affairs. One thing a lot of people don't know is, or they get confused about, is the power of attorney. It's only effective during your lifetime. So we have clients that come all the time and say, well, I can get in my dad's bank account because I've got his power of attorney. Well, your dad passed away, so that doesn't work anymore. Now we have to go through your will. Who's your executor? Same thing with your medical power of attorney, which you won't need after you pass away anyways. We can limit it as much as you want. We can make it as broad as you want. Some people say, well, I'm going to be out of town on vacation next month. My house is selling. So I want my son to be able to sign the closing papers for my house while I'm gone. We can limit it to something just like that, or we can just make it broad. You've got several different healthcare documents. Jody mentioned them earlier. You've got your medical power of attorney, which is some document that you appoint someone to make your medical decisions on your behalf. The difference, one of the main differences between that and the financial power of attorney is if I name my daughter as my medical power of attorney, she can't just haul me into the hospital if I'm capable of making my own medical decisions and tell them to perform surgery on me. So that only comes into effect once you can't make your own intentions known to your physician. The directive to physician, some people refer to that as a living will. What that does is that gives you the option to make the decision on how you want to be treated if you are going to be on life support and the doctor doesn't think that you're going to recover ever. You can choose that you be removed from all life-saving and sustaining treatment and be kept comfortable, like hospice. You can also say, I don't care what state I'm in, keep me alive for as long as you can on whatever machine you've got. I've had 2 people in about 20 years make that selection, and which is fine. Some people don't sign a living will or a directive because they want their medical power of attorney to make that decision based on the factors that are there at that time. Personally speaking, Gail didn't sign one of these because she wanted me to make that decision for her, knowing everything that was available to me then. And I told her, I said, I'll just pull the plug. I'm not going to let you lay around in the bed. And then on my side, I wanted to sign one of these because I did not want her to have to make that decision. I've seen it too many times where someone doesn't have one and children can't agree on what to do. Mom doesn't want to let her husband go. That's why I did it. She eventually came around, so she signed one now, but that's an important document to have. HIPAA release form, you know, we're in Fredericksburg. Things are pretty lax with the hospital. They know most of us. They know most of our families. Where it comes into play with the HIPAA is if you go to another town, to a bigger hospital, they don't know who you are, they don't know your cousin. What that does is that says, I'm going to have a list of people on here who can have access to my medical records. They don't make decisions on your behalf. They can just get information from a doctor's office, from a hospital. If you're in a car accident, they can call in and say, I'm on the HIPAA form, how's dad doing? So those are important documents to have in place. So how do we get started? Well, sit down and talk with your family and see if you've got these documents in place. If you do, review them, see if they still meet your intentions or your goals. Some people do a will, they put it in the drawer, and then they say, we're good. 25 years later, they saw that they had an uncle listed as an executor and somebody was guardian over their child because they were 2, now their child's 40. So keep them updated. If you don't have one in place, what we typically do is we'll typically give you a client information sheet where you can list your family members, you can list the assets you have, their approximate estate, who you want in those positions as executor, as beneficiary, as medical power of attorney, financial power of attorney, so we get a pretty good idea what you want before we meet. And then, schedule an appointment, talk to an estate planning attorney. It doesn't have to be me, but just somebody that's qualified to do it. There's a lot of attorneys that do general work and a little bit of everything. Well, this is a pretty important subject. So, make a plan, talk to your family, see if everything is how you want it. If you have one in place, if you don't, you need to get one. And that is all I've got. So if anybody has any questions, feel free. I'm not going to answer any specific estate questions or personal questions about finances. But if you've got general questions on the topic, then feel free to shoot them at me. And if you want to come see me in the back a little bit later with a question, certainly you're able to do that. Thank you all very much. I appreciate it.
Are there any questions? Yes, Mary.
Yeah, could you just say again what the real difference is? Will you say again what the real difference is in why you want to do a trust? It sounds like you do a trust to avoid probate, and you do probate to avoid the government. Okay?
Right.
What's the difference in probate and trust?
Okay, so the question is, what's the difference between having a trust in place and not having a trust in place and having to go through probate? Well, if we've got assets that are listed or titled in the name of a trust, if I pass away, those assets automatically go where the trust says they go. I don't have to go to court. My kids don't have to go to court to probate my will, to take a month or two to do that, and then we have to do an inventory. If I've got something listed in the name of a trust, they can automatically go to the next person down the line. If I have a will and if I don't have a trust, then we've got to file that will with the court for the judge to approve it and appoint an executor to act on our estate's behalf. So it takes a little bit longer to do. The timing, yeah, and it's not significant. I talked about there are exceptions, obviously, but those are the main two differences. Is if you've got a trust, those assets automatically can go to the beneficiaries. If you've got a will, then we've got to wait for the court date, and then we can distribute those assets.
I have a question.
Yes.
So there's the revocable and the irrevocable.
Yes, ma'am.
So would an irrevocable trust, how would you ever end it? Like, do you know what I'm asking?
Absolutely.
Like if somebody does and you are the beneficiary or whatever of the irrevocable, you're named in that, can you ever get rid of it?
Good question. And the answer is standard attorney answer, it depends. The question was, if I've got an irrevocable trust that I can't change and I'm a beneficiary, when does it ever end? Well, you can list when it ends. So you can set a trust up for somebody that lasts until they're 35. I may not want my 21-year-old college student having access to a bunch of money. Not that they'll get it from me anyways. You can have it for a term of years. You can say, okay, well, the trust ends when my son passes away, and then it goes to his kids outright and free from trust. You can also say it goes on for a few generations, and there's a complicated formula about how long you can make a trust last in Texas, but it's typically 3 generations if you want it to last that long and to go from family member to, down the bloodlines to the next family members. So that was a good question. So it depends. You can change it. Everything is customizable.
Any other questions?
I think your mom has one.
Oh, you can't ask one.
Last year, you told us the story about
Uh-oh.
someone who died intestate. And you didn't tell us this time. And there's some people here that didn't hear that. And there's
Gotcha.
40% of the world doesn't have a will. So would you tell us that story again,
I will.
please?
Yes. So, like I said earlier, we've got probably about 60% of adults don't have wills in place. If you die without a will, the state of Texas sets up that family tree to say who gets your property, who inherits from you. We had a dear old client. She was on her second marriage. They were both in their 90s. Husband passed away. She had a nice little bank account with a few $100,000 in it, and she had a 500-acre ranch out near Harper. Her second husband's kids took care of her for the last 10 years of her life. And obviously she would have wanted her assets to go to those kids. She didn't have kids from her first marriage, and she wanted everything her intention was for them to get the assets. Died without a will, didn't have anything in place. Those kids didn't get anything. There was 97 heirs all across the continent and even overseas that got a chunk of her land after it sold and got a chunk of her bank account. I think our smallest share was 1 247th or something like that. So you had 97 people that inherited the money from a 500-acre ranch that had to be sold, and then inherited the bank account. And another thing is, with that scenario, it probably cost $20,000 in attorney's fees for us to figure out who those people are. And then once you figure out who they are, you've got to give them notice. So we have to do certified mail to 97 different people, get them to approve a sale of property that they've never even heard of. So that's the story you're talking about, Sharon?
Yes.
Okay. Yes, ma'am.
Get a will.
So the children that she intended to give, her estate to, they didn't get it because they weren't family members?
They weren't her children. They were her second husband's children.
That's what I mean. So
Yes,
they
ma'am.
were not
They weren't
family.
bloodline family members.
Okay, got it.
They were part of the 99.
Got
And if you have a will saying that they will get it.
it. Okay.
Right. Right. If you're not
It's
related,
basically like if they have the same last name, they can go, hey, I know Aunt June. Where's my money, right?
right.
So,
Yeah. So it tells us how the family tree works, and if you have kids, it goes to your kids. If you don't have kids, it goes up to your parents, and then it goes to your siblings. And if you don't, then it goes to your grandparents and uncles and aunts, and it just goes all down the family tree. Anybody else?
any more questions? The meal's about to come out. All right. Like he said, Chris is going to hang around
For a little bit.
for a little bit. He's got 5 kids and a wife at home. He can't stay long. And he's not going to answer specific questions for you. Don't say, hey, my grandparents have this, this, and that. If you got a question about the presentation that you didn't want to ask now, please feel free to ask him. Fill out your comment card, because remember, he is generously donating a large valued gift. For some people, it could be $500, it could be $200. It's depending upon how difficult your setup is. But please fill out your comment card, because what we're going to do when the food gets ready is you're not going to get through the line until you have one of Chris's cards. What do you mean by that? What I mean by that is when I bring you your table a card of Chris's and you have your comment card, then you will go through the line. We're trying to just let everybody sit down, chill for a while. We got plenty of food, chat with your friends and new friends. But again, thank y'all for coming, and we will get started shortly with the food. So thank y'all for coming.